Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, counsel. We are ready to hear the first case on our docket, Johnson versus Martin. We're ready to hear from the appellant. You need to, your audio isn't on. There you go.
May it please the court, Jim Hankins for the appellant petitioner, Mr. Johnson. The briefs, I think, encapsulate the issues in this case. There are a couple of things I'd like to emphasize to the court about, particularly about this Batson claim, that would complement the brief. The first one is the nature of patterns. And in Batson itself, the Supreme Court has recognized that a pattern of striking minority jurors can constitute a prima facie case of racial discrimination. Now, as a practical matter, when defense counsel is physically present in the moment during jury selection, the nature of patterns is that we see them in the present only by looking at the past. So when a prosecutor strikes a minority juror for the first time, is that a pattern? Well, typically not. And what I'd like to emphasize to the court is that, you know, defense lawyers, myself included, and I've done this before, we're not flippant about making Batson challenges. It is, we can just be candid here, it is an accusation that a government lawyer is exhibiting racial animus in open court. So well, it's something
here you had the striking of 5 minority jurors in a row. Is that not right? Or at least five minorities, whether they were in a row or not, I don't recall.
That's correct.
And that is when defense counsel raised the question of whether or not that was too much.
That's correct. And that's kind of the point I'm making, is that and I've done this myself in jury trials, sometimes you let some of it go because you're not really sure, but there's a tipping point where we have a problem here. And that is what defense counsel did in this case. And that informs how the record is presented in the appellate courts.
Now, so, in this case is a 2254. And so we're correct. Looking at the ruling of the OCCA. Did the OCCA correct. Err in their handling of this case?
Well, of course they did.
In what way?
By misapplying Batson in I would say an irrational way. We have a summary opinion here, which is basically one paragraph with conclusions devoid of any analysis. The primary way is that, and this is actually fairly shocking to me, the Court of Criminal Appeals viewed this record as the trial court, you know, when it came time for the prosecutor to strike the last African-American juror on the panel, it was the trial court that actually said, wait a minute, I didn't see a pattern when you were striking them all before, but now you want to clear them all out, so I'm not going to let you do that. In our view, that is a implicit, if not explicit, finding of a pattern of racial discrimination. The Court of Criminal Appeals viewed that and said, well, the trial court erred in even doing that to the detriment, and I want to read it, to the detriment of the state, which...
Did the OCCA correctly find the facts in this case?
Not in our view, Your Honor. The summary opinion, in our view, expresses legal conclusions. And in particular, if we're applying the AEDPA, there should be no deference because, well, even if there is deference, the legal conclusion reached is unreasonable, because Batson sets forth an analytical framework, and there's a reason why the Supreme Court did it that way. Because is there a prima facie showing? If so, it is the duty of the trial court to inquire of the prosecutor to articulate a race-neutral reason.
Well, can I stop you there, counsel? Because isn't that kind of the problem, is that your argument you're making here, and you did make it at the post-conviction level, but you didn't make the argument at the direct appeal level that you're making now, which is that at step two, it's the prosecutor who must state his race or her race neutral reasons. And here the district court essentially stated them, but you didn't object to that at the direct appeal level. And the state points that out now in their briefing now, that this wasn't the basis for your objection. And I don't see that you really responded to that in your reply brief. And isn't it procedurally barred by not raising it on direct appeal?
No, Your Honor, I believe it. Are you talking about the
Your
direct
step
appeal
two-
in the Court of Criminal Appeals?
Yes. Your step two objection that you're making now.
Well, I believe it was raised, Judge. I believe it's encapsulated in the entire Batson claim.
Well,
I wasn't direct appeal counsel.
I understand, but I do think it's different. The way I read your direct appeal claim and the claim that the OCCA ruled on, you didn't discuss the fact that it was the judge who essentially provided the reasons versus the prosecutor. And if I'm understanding your claim correctly, that's sort of the essential aspect of your claim at this point.
Well, it's not the essential aspect of the claim. It's the reason why the opinion of the Court of Criminal Appeals is incompatible with Batson. I mean, that's just...
Well, I'm not sure that the Court of Criminal Appeals understood that point, is because I'm not sure you specifically made that argument.
Maybe put another way, was Batson fully raised before the OCCA? I guess that would be the only way you get to the point of whether or not you argued that the trial judge relied on his own reasons.
Well, it was raised and decided by the Court of Criminal Appeals. The record shows what it shows. The Court of Criminal Appeals cited Batson, cited Snyder, and ruled that there was no even an indication of racial discrimination.
Well, the point is, I think that it is how was Batson violated? And I think you're arguing something different here than was argued on direct appeal. Is that not right?
No, Your Honor. I disagree with that.
I have a question, counsel. Do we know the racial makeup of the jury?
Not from the record. I do not, Your Honor.
And how do we decide anything? My other question is, when you say minorities, are you talking about all African Americans, or were some of them Hispanic?
That is also unknown. That's why that was
difficult to say there's a Batson problem here, because we don't know how many minorities were left on the jury. Do we? Well,
we know what trial counsel said. Trial counsel objected to 5 out of the 6. And we know what the reaction was of the trial court. Judge Gillert didn't say you're wrong about that. Judge Gillert said, okay, that may be true, but I don't detect that as a pattern. And the prosecutor in this case didn't pipe up and say, defense counsel, you're wrong. So they're.
But those are the people that didn't get on the jury that we know about. We don't know what's left, do we, in terms of minorities?
Well, I don't know that is even relevant under Batson. The evil that we're combating here under Batson, the Supreme Court has told us, is the racial strikes themselves, not the composition of the jury. The ultimate composition of the jury, I don't think, is part of the Batson analysis.
Well, but if the remaining jurors are 50% African American, no harm, no foul, 60% African American? Or
well, again, I think the final, I think the final composition is not really the focus of a Batson issue. The second thing I'd like to point out is a cumulative error issue was granted, or certificate of appealability. And there is in our view, a credible claim by a juror that Mr. Johnson was convicted, in her words, on the basis that he was quote unquote black. So sometimes in these Batson claims, it is difficult, and maybe this goes to your question, it is difficult to determine the prejudice. What is the harm? Apart from just the racial strike itself. I think we have a unique case here where I think we can show the harm. And to go to your question, if there was a more diverse jury panel, would racial considerations be part of the jury sentencing calculus? I think it's very unlikely not. And then you have to, and I have to emphasize, Judge Gillert refused to allow the state, even if he's finding no racial discrimination, he's not allowing the state to strike the last African-American juror. To me, that says a lot. It really drives the point home here.
So that we do know then. I was looking for that comment by the trial judge. And that is, and I quote, well, you would have effectively eliminated all of the African Americans, and I'm not going to do that. So we know then that there was one black juror.
Correct.
That is, to Judge Seymour's point, we don't know if there were other minorities on the jury.
That is correct, Your Honor.
But you're saying that's not the point. It's how you select the jury, not who's remaining on the jury.
Well, that's the point that's the point the Supreme Court emphasized in Batson, yes.
Right.
One other aspect of the case, and this is I guess goes to the gruesome photographs or gruesome testimony claim. And I got to be honest, this claim very rarely gets any traction, much less a certificate of appealability in this court. But, I think there is a reason for that. Number one is the testimony and the photographs were clearly excessive. But the main point is there was no dispute during the trial. Factually, Mr. Johnson did not personally commit the murder here. Very attenuated and tangential part he had, if you believe the state's theory of this case. So when the court considers this issue, there's a reason why, and, when defense counsel, and I've done this myself at trial, we'll stipulate that there's a death. We'll stipulate to the manner. We're not contesting any of it. And typically the prosecutor will say, no, we want to put on all this evidence. There's a reason why the prosecutor does that. And it's because they can make the closing argument that they made here and emphasize this sort of evidence that is based on an emotional reaction to lay jurors who are not accustomed to hearing graphic descriptions like that, much less seeing it in color photographs. So there is, in this case, I think the Batson claim is very clear to me, but the other claims are as well. And then when you inject the cumulative error component to the issues in this case, there is palpable prejudice on all of them. I see I'm about out of time. I think that's
Thank you.
pretty much all I have to say, unless there's some questions.
Thank you. We'll hear from the appellee.
May it please the court. I'm Tessa Henry from the Oklahoma Attorney General's Office on behalf of the respondent, Jimmy Martin. So I'd first like to talk about petitioner's Batson claim. And I think it's very helpful to go through the specific facts of this claim to clearly show that this claim is meritless. So I'm going to go really quickly through the prosecutor's peremptory strikes. So first, the prosecutor struck Mr. Twill, and then he struck Mr. Dickens. And as he struck Mr. Dickens, the trial court sua sponte requested a race-neutral reason from the prosecutor because Mr. Dickens was Black. The prosecutor provided the race-neutral reason that Mr. Dickens was an English professor. He had a PhD in liberal arts, and in his experience, such jurors were too exacting, and he didn't want someone like that on the jury. From there, he struck Ms. DeWassam, Ms. Wilson, Ms. Carranza, and then Ms. Martinez. It was at that point that defense counsel raised a Batson objection and argued that 5 of the 6 peremptory strikes so far of the prosecutor had been of minority jurors.
And isn't that a pattern?
No.
It just looks like one?
That was all he offered as far as argument to the trial court, just simply the number. And we don't have anything specific as to what minority these jurors were. We know for sure that...
Well, wouldn't that be enough to establish a prima facie case, which should cause the court then to inquire of the prosecutor what the race-neutral reason is for the strike?
In some instances, perhaps, but here we're giving the trial court a great amount of deference because the trial court is the one that's watching this, that can gauge credibility. And the trial court was faced with simply an argument of, well, here's 5 of 6 jurors. But the trial court could see that there were obvious reasons on the record for why the prosecutor struck these prospective jurors.
That's not the trial court's role, though, is it?
Well,
not under Batson. It's a 3-step process.
Yes, it is a 3-step process, but the first step is for the petitioner to present a prima facie case and raise the inference of discrimination to the trial court. And because the petitioner argued nothing more than the number, and because the trial court could see neutral reasons on the record, the trial court clearly did not see discrimination in an inference.
I'm sorry.
Okay.
Counsel, what about the fact that the trial court, first sentence, he says, well, I don't think that establishes a pattern. The next sentence, again, in terms of Ms. Martinez, I won't state their reasons for them, meaning the trial court seems to be saying, I'm going to ask the prosecutor for reasons. I'm not going to state them for the prosecutor. And then what does the court do? It proceeds to state the reasons. Apparently, what else would you call that? When it then says, but Ms. Martinez, she was involved in the process. Ms. Carranza had difficulty with English, on he goes. What would you call that other than stating the reasons when he says, I'm not going to state the reasons, but then he does?
That was the trial court finding no inference of discrimination on behalf of the prosecutor by pointing to those obvious neutral reasons on the record for why these jurors were struck. The trial court didn't feel it necessary to go further to step 2 to request race-neutral reasons from the prosecutor because the trial court didn't feel that a prima facie case had been made.
So basically, I'm not going to state the reasons for them because I don't need to because it's obvious. Is that what you're suggesting we would infer there?
Yes. And the trial court's observations are absolutely supported by the record. He specifically talked about Ms. DeWassam and Ms. Carranza's difficulty with the English language. And earlier in voir dire, the prosecutor had actually attempted to strike Ms. DeWassam for cause because of the English language barrier. English was her second language, and she had only been speaking it for about 15 years. And she said she felt uncomfortable and didn't know if she'd be able to understand everything. So clearly, when you have that from the prosecutor previously trying to strike her for cause, that's obviously a neutral reason on the record that the trial court can see.
What was remind me what the Miss Martinez, the trial court said she was hardly involved in the process. What did that mean?
There are several different things from the record. First of all, she explicitly said she didn't want to be on the jury. She also mentioned that she didn't believe it was fair that her brother was jailed for a DUI. She didn't think jail was appropriate. And then in other instances during voir dire, she just didn't seem interested, and she would respond with very short responses. She just wasn't engaged like the other prospective jurors were engaged in the process.
Well, that sounds like something to me the trial court should have inquired about the prosecutor. Apparently, there might be several reasons why the prosecutor might have struck Ms. Martinez, but we don't even know what those were because we've got this general statement. She was hardly involved in the process.
Yes, but I think that is absolutely supported by the record.
But that's not what Batson tells us to do. The whole point is whether or not jurors are being struck for a racially discriminatory reason. That is, what is the motivation of the prosecutor? It's not what the judge thinks. It's what is the motivation of the prosecutor, which is the question that the judge should be asking of the prosecutor. Right? Is that a correct reading of Batson?
Well, I think if the inference of discrimination is not raised to the trial court can fairly decline to go to step 2 of Batson. And I'll quickly quote a case here.
I was going to say, can you discuss what case law you rely on for that, please?
So Johnson versus Campbell from the Ninth Circuit is one case where the court stated that there was the presence of obvious reasons for the peremptory challenge on the record, and the trial court didn't find, based upon that there was a prima facie case made, and the court agreed that the trial court did the right thing in not pursuing the matter to the second step of Batson.
What were the obvious reasons in that case?
I'm not sure, Your Honor. I do not recall.
Is the Batson issue procedurally barred?
A portion of it, yes. Petitioner did raise this Batson claim on direct appeal. However, petitioner only focused on the prosecutor's race-neutral reasons that were offered and argued that the race-neutral reasons were untenable and that the trial court shouldn't have found a lack of discrimination. He did not, however, raise the argument that the trial court improperly imagined race-neutral reasons for the prosecutor. That was not raised on direct appeal and was not raised to the Court of Criminal Appeals.
Is it enough for the appellant to say Batson has been violated here?
No, not necessarily, especially when he focused his argument on such a specific piece of Batson. Much of his proposition was discussing Juror Dickens and how the prosecutor's reasoning that Juror Dickens was too educated was an illegitimate race-neutral reason.
But Johnson did argue on direct appeal that the prosecutor, in violation of Batson, systematically and intentionally removed minorities from the jury. Is that not right?
Yes, he did argue that.
And did the OCCA correctly determine the facts on that question?
Yes, they did.
Could you explain how they did?
Yeah.
Yes. So the Court of Criminal Appeals reasonably determined that petitioner had not shown discrimination on the part of the state And the Court of Criminal Appeals actually specifically cited Mitchell versus State. And the paragraph that they cited to lays out the 3 Batson steps. And they also cited to Batson itself. And the Court of Criminal Appeals also found that the state's explanations, the race-neutral reasons offered by the state, when it did offer race-neutral reasons, were legitimate, and the trial court reasonably found no discrimination. So I think
did they say that the prosecutor gave the reason at the second step?
They did say the state's explanation for excusing minority jurors.
Is that factually correct?
The state did offer, yes, 2 race-neutral reasons during the Batson challenge. First,
go ahead.
First, as to Juror Dickens, which we've already discussed, the PhD, and then when the prosecutor attempted to strike Juror Williams as his 8th peremptory, he himself provided his own race-neutral reason based upon the fact that Juror Williams was Black, and he reasoned that she was a pastor and perhaps wouldn't be willing to impose judgment upon petitioner, and that she had worked with drug addicts in the past and perhaps would favor treatment rather than imprisonment in most cases. However, even though that was a race-neutral reason, the trial court did not allow that strike.
What do we do with the trial court in this case giving its own reasons? And does OCCA acknowledge that that is what happened factually?
They do not explicitly discuss the trial court finding obvious neutral reasons on the record, no. But again, that specific aspect of that claim was not raised to them on direct appeal. It was not raised until—
Well, they concluded that the prosecutor gave a race-neutral reason. And when we look at the record and see in several of these instances, there was no race-neutral reason given by the prosecutor, but instead it was given by the trial court. Isn't that an error of fact?
No, because there were clear race-neutral reasons offered by the prosecutor as to Juror Dickens and Juror Williams.
Well, he offered the Juror Dickens reasons because the trial court asked for them, first of all.
Yes.
Not defense counsel, and we don't have anything from the prosecutor on at least 3? How many of them? 3? We have nothing at all from the prosecutor as to the race neutral reasons for 3. And the objection was to the pattern. And so presumably that's the objection that the OCCA was dealing with. And so the OCCA clearly did misstate the facts if they suggest that the prosecutor gave race neutral reasons as to the pattern objection. The prosecutor said nothing at all on 3 of these individuals.
The prosecutor said nothing because petitioner had not shown a prima facie case of discrimination, had not raised an inference of discrimination in the trial court's mind.
Maybe the prosecutor said nothing because the trial judge had already said it for him.
So you're saying in this case, there's absolutely no evidence of a pattern of racial discrimination in the striking of jurors?
No, and we have to—
No, what? That is your view? There is no prima facie case here?
No, not as to the Batson objection raised by petitioner. And that comes from— we have to give the trial court a great amount of deference in these Batson claims because they are there and they are experiencing it and they are viewing it firsthand and can judge the credibility of the prosecutor, can judge the credibility of their prospective jurors. So we have to give the trial court a great amount of deference as well as the Court of Criminal Appeals as far as this Batson claim. And with that, I see I'm out of time, so we would respectfully request that this court affirm the district court's denial of habeas relief.
Thank you. Mr. Hankins, you have 48 seconds.
I'd like to address this procedural default issue. With respect, it sounds like Your Honor is conflating your role in a federal direct appeal where trial counsel doesn't say the words appropriately, and is that plain error? Procedural default is, did a state appellate court impose a procedural rule to not address the merits of a claim? The Oklahoma Court of Criminal Appeals did not invoke any procedural rule. It did not bar the claim at all on any procedural matter. It addressed it on the merits. And as the Supreme Court has told us, the Court of Criminal Appeals doesn't even have to be aware of that. It just has to issue an opinion. And this court has to review that opinion, and it can't be squared with Miller L. v. Dredke or Flowers v. Mississippi.
Thank you. Thank you both for your arguments this morning. They're very helpful. The case is submitted. Our next case for argument is United States versus Davis. Mr. Jackson, want to proceed?
May it please the court, Robert Jackson appearing on behalf of defendant appellant Amy Lee Davis. This appeal is about the piling on of cases and conspiracy allegations such that Ms. Davis was convicted of a conspiracy which either didn't exist or for which she was not on trial. First, the evidence was insufficient to sustain Ms. Davis's conviction as to the conspiracy charged in count one. The government's theory of Ms. Davis conspiring with Carlos Venegas and her sister Cindy in relation to drugs seized during this November 13th traffic stop had completely fallen apart by the time the case was submitted to the jury. Second, and as an alternative,
don't we have a broader charge than that?
I don't believe so, Your Honor. I don't believe that the government intended
I'm looking at the indictment, and it says Davis, and then lists Venegas and Davis, Cindy Davis, together and with others known and unknown. So we've now removed Venegas and Davis, and so now we have our defendant, Amy Lee Davis, charged together with and with others known and unknown. So isn't that enough?
No, I don't think so. And there's a big problem with that instruction number 17. It's so broad that it encapsulates any drug conspiracy conduct occurring between June 2018 and June 2019. And it's this huge window. And my client, Ms. Davis, pled guilty to 2 additional drug conspiracies in that time frame. And that's what really concerns me here. Also, we know that the government's conspiracy allegation was narrower and confined to this November 13th traffic stop if we look at the trial record, and also if we look at the other counts in the indictment. The other counts in the indictment, they all centered around this November 13th traffic stop. Count 2 had to do with possession of the drugs from that November 13th traffic stop. Count 3 had to do with maintaining a dwelling place for purpose of distributing drugs. And that count ends on November 13th, the date of the traffic stop. Count 4 has to do with using a telephone or communication facility to facilitate the drug conspiracy. And that occurred on November 13th when Ms. Davis called her sister, Cindy. Count 5 is an outlier here. And I admit that that doesn't run with the November 13th traffic stop, but that's a possession with intent count that was picked up by Ms. Davis while she was absconding from a state court warrant for these charges relating to the November 13th stop.
What authority do you rely on, Mr. Jackson, for the concept that because the other counts, the non-conspiracy counts, refer to these separate events, that somehow the conspiracy count must be restricted to the individuals involved in those events, or that it somehow restricts the very broad conspiracy count? Is there any authority for that?
I think the authority, if we look at all these general conspiracy cases and the variance cases where we talk about Kadiakos and going way, way back, where there's a broad conspiracy alleged and the narrower conspiracies are proven at trial, I think that would be the authority we look to. But here, the conduct of the government.
I guess if I was speaking more, I should have said from the sufficiency of the evidence count.
Okay.
If we're just looking at the sufficiency of the evidence, which is your first argument, why would we look at the other counts to determine whether the evidence was sufficient for this count?
Well, here we have to determine what conspiracy was charged. And this is really troubling. Miss Davis was charged in 4 separate drug conspiracy cases, all occurring in the same time frame.
With different.
One of those cases was just.
Counsel, wasn't the charges were with different people because she was selling meth to multiple people. So the other conspiracies didn't include these same parties. They included other parties, other people that she conspired with or sold drugs to. Is that right?
We don't know that, Your Honor. That's especially problematic. The government now cast for the first time on appeal these witnesses, Cobello and French, as, quote, unindicted co-conspirators. What's to say that Cobello and French weren't part of the conspiracies in the 2 other cases to which Miss Davis pled guilty? And then Mr. French was charged in.
Can't we look at the indictments in those cases and see whether they're the same people? Aren't they other people that are charged in the other indictments with her?
Sure, there's other people in those other indictments, but what's to say that there weren't also unindicted co-conspirators included in those cases?
Why are we looking at the other indictments? We're focused here with this count 1 in this case in front of this jury. And this jury didn't hear about these other cases before other judges.
We have to be concerned with the other cases because all the date ranges are the same. And that's the big problem here. We're hearing about drug conspiracy conduct occurring in the same date range as count 1 was alleged to occur. So we end up with this problem, this very big problem, where Miss Davis may likely have been convicted of some conspiracy that was not fairly included in count 1. And if we look to that Evans case, that's what that case was about.
So you're arguing here that she was without notice of what she was being charged with?
If we're talking about prejudicial variance, yes, Your Honor, that's one of the components there.
Was a bill of particulars filed here in this case? Do people still do that? You know what a bill of particulars is?
I do, Your Honor. No motion for bill of particulars was filed.
So if there was any issue on notice, wouldn't that be the likely thing to do? If she said, gosh, I'm going to trial and I have no clue what they're charging me with.
It's a little more nuanced here. Miss Davis goes to trial and her indicted co-conspirators are this Carlos Venegas and her sister Cindy Davis. Just prior to trial, all charges are dismissed with respect to Mr. Venegas. Cindy Davis, she's severed out. She testifies at trial. Apparently that was part of a diversion agreement. And by the time she's done testifying, the government agrees during Rule 29 argument that Cindy Davis is no longer a co-conspirator. So 2 additional witnesses were presented at trial, Cobello and French, and there the government referred to those people as, quote, insiders. Now for the first time on appeal, they're being referred to as, quote, unindicted co-conspirators as the government's effort to save the conspiracy conviction. So in terms of those people being cast as co-conspirators, for the first time that's happening on appeal. So in terms of notice, there was no notice fairly included in the indictment or in the arguments at trial that Cobello and French would be cast as, quote, unindicted co-conspirators.
Would the jury, given the instructions they had, could they have concluded on the evidence given that Cobello and French were co-conspirators?
I suppose the jury could have and may very well have concluded that Miss Davis conspired with Cobello and French, but that conspiracy with Cobello and French was not fairly included within count 1. Those people were not cast as co-conspirators at trial. They weren't cast as co-conspirators during closing arguments. And that's where the variance comes into play. Going back to the jury instructions, they're especially problematic here. Those jury instructions failed to explain that Ms. Davis could only be convicted of the drug conspiracy specifically alleged in count 1, and not some other conspiracy she may have participated in during the same time frame. The district court failed to give that multiple conspiracy construction that's contained at pattern instruction 2.20. And that instruction would have informed the jury, among other things, that, quote, proof that a defendant was a member of some other conspiracy is not enough to convict. This language was so critical, considering the number of conspiracies in play, all occurring in the same time period.
So you're arguing the jury instruction 18 was in error?
We're arguing that jury instruction 17 was in error because it did not include Cindy Davis's name. Trial counsel
is 18 okay?
18 as to that.
That's
as to the elements.
Yeah.
Yes, Your Honor, that we don't have an issue with 18. It's Ms. Davis's position that an instruction such as pattern instruction 2.20 should have also been included, alerting the jury that multiple conspiracies were in play, and that Ms. Davis could only be convicted of that specific conspiracy in count 1 surrounding that November 13th traffic stop.
How did the jury, why would the jury be aware of other conspiracies?
Well, they should have been made aware of other conspiracies.
Why?
So that we didn't have this problem or this issue of an erroneous determination, the conviction for conspiracy with Cobello and French that was not included, fairly included within count 1.
Why aren't, I'm sorry, go ahead, Judge Seymour.
Your turn.
I'm sorry. Well, I was just going to say I don't understand that, because I don't understand why Cobello and French weren't clearly the named or unnamed conspirators that are referred to in the language of the count. I mean, the specific language, and named or unnamed conspirators. That's Cobello and French.
I disagree, Your Honor. The way this case was charged, the instruction 17 should have read Amy Lee Davis along with Carlos Venegas and Cindy Davis conspired. And by the time it went to the jury, that case fell apart. So now it's just this one woman crime spree. Amy Lee Davis conspired with others known and unknown over this huge year date range. Cobello and French just barely weren't included in that, and they weren't cast as unindicted co-conspirators.
Have you raised a double jeopardy claim here? I mean, that's really where you're headed. You're saying, well, there's a lot of the same thing going on here, and she's pled to the same thing and being convicted of the same thing. Is there a double jeopardy problem?
There could be, Your Honor. I don't know what that jury convicted Ms. Davis of. That's the problem here. We mentioned double jeopardy in the ground 2 variance claim, but that's a potential ramification of Cobello and French's testimony. As a standalone claim, no, Your Honor, we haven't raised that. In conclusion, all 3 of these grounds for relief focus upon how Ms. Davis was erroneously convicted of the count 1 conspiracy, a conspiracy that just simply wasn't proven by the time the case was submitted to the jury. Ms. Davis's conspiracy conviction must be reversed, and I'd save any remaining time for rebuttal, Your Honors.
Thank you. Ready to hear from the appellee?
Thank you, Your Honor. May it please the court, counsel, Joel Lynn McCormick on behalf of the United States. The district court properly determined there was one conspiracy. There was no variance. At trial, there was one defendant before the jury to determine whether or not she was guilty of the charges beyond a reasonable doubt. All of the evidence presented was in relation to the appellant's participation in a vertical conspiracy in which she supplied methamphetamine to others and relied on them to redistribute it. For that reason, the court was also proper in its determination that a multiple conspiracy instruction was not appropriate in this case. Based on the evidence, the jury had before it substantial evidence of a single conspiracy where the appellant conspired with a source of supply in Oklahoma City who was unknown, and at least two known conspirators, Cabela and Mr. French, who both testified before the jury. The substantial evidence before this jury included direct testimony before both known conspirators. Starting with Mr. French, the jury heard evidence that he was supplied methamphetamine by Miss Davis multiple times a month. He described locations where he met Miss Davis. He also referenced that he knew her source of supply, who was supplying her with the methamphetamine that she was redistributing to him, was in Oklahoma City. Likewise, the record also reflects that Mr. Cabela also testified that he bought methamphetamine from the appellant on an almost daily basis. The testimony even goes further from Mr. Cabela in his description that Miss Davis fronted methamphetamine to him. Mr. Cabela describes that the appellant supplied him with vehicles to drive so that he had transportation to distribute the methamphetamine. She supplied him with firearms for his protection. And he too, like Mr. French, knew the source of supply was in Oklahoma City. Your Honors, this evidence was substantial evidence for the jury to reasonably conclude that there was one conspiracy, and it's that conspiracy that was charged in count one of the indictment.
Was it argued before the jury? And I think were you trial judge, trial court on this? Excuse me, trial counsel on this case?
I was, yes. Your Honor.
Did you argue before the jury that these individuals that you just named were co-conspirators?
Your Honor, I did argue that, and counsel focuses on the term insiders. But I think what's important as far as what was presented to the jury was the evidence. And the evidence was regarding supported the agreement between the appellant, Ms. Davis, Mr. French, and Mr. Cabela, as well as the source of supply in Oklahoma.
So again, you did not refer to them as co-conspirators, is that right?
I did not use that term, Your Honor. However, the argument referenced the evidence that was presented to the jury that supported the jury's reasonable inference that there was an agreement between the appellant and these two gentlemen who testified before the jury.
It seemed like maybe your position kind of changed. It seemed like your opening argument didn't reference, as I recall, these two individuals, Cabela and French, at all.
In Your Honor, in opening statement, I don't recall specifically whether we referenced them by name, but it was certainly not a surprise to the government that it wasn't a last minute decision that we called them during the trial in this case. And I want to clarify one thing for the record that I think is kind of lost in the appellant's argument. The appellant in this case is not charged in any other conspiracy with Mr. French and Cabela. She is charged in other conspiracies, which is a clear indication that a grand jury took very specific steps to ensure that while there were multiple conspiracies that set out in multiple indictments. But the matter before this jury that was considered based on the evidence is not a spillover. And I think that's important in reference to the inferences that are made that suggest that the appellant is charged in other cases with the two co-conspirators who testified in this case. That is not true. Your Honors, I would further argue that based on the evidence that there was a single conspiracy, the district court was also proper in its instruction to the jury. The record clearly reflects what the government would characterize as an affirmative waiver, in that when the district court provided the proposed instructions to counsel for review, trial counsel for appellate simply asked the question, is there a multiple conspiracy instruction included? And the answer from the court was no. There was never a formal request submitted by the appellant for a multiple conspiracy instruction. We returned the second day after the exchange that I just described, and still there was not a formal objection raised in reference to the omission of a multiple conspiracy instruction. And so the record is void in reference to an actual request for a multiple conspiracy instruction. And this jury was instructed based on the evidence that was presented during the trial.
After review of the instructions by counsel, did the defense counsel agree or say those are fine, we have no objections, or something to the positive?
Trial counsel the next morning it did not submit anything, and he did make reference to an objection to there not being a multiple conspiracy instruction, Your Honor.
Okay.
So he objected to the fact that there wasn't one? Are you saying? I don't understand that.
Yes, Your Honor.
Do you have anything else?
Your Honor, I would just, in closing, argue that even if this court finds there was a variance, which we maintain there was not, but even if the court finds there was a variance, we would ask the court to consider the fact that all of the evidence presented to this jury was directly related to the appellant's possession, distribution, and redistribution of methamphetamine. There is no spillover effect, or there was no prejudice. And so if the court is guided by its previous decisions in other cases, we'd ask the court to look at Carnegie. That's a case where there actually was a variance. And by comparison, I'd ask the court to consider the fact that in Carnegie, that case involved a multiple defendant jury trial. There was clearly spillover in that there were 3 defendants who were before the jury for trial. And part of the evidence before the jury was that there were times when the alleged co-conspirators were actually competitors. And so there was room for there to be a decision that there was a variance. However, the court in that case determined that a jury would have been able to reasonably compartmentalize the evidence that was presented, and therefore there was no prejudice. In this case, we have a single defendant who was before the court for trial. All of the evidence, when taken in the light most favorable to the United States, a jury was reasonable to infer that this appellant was charged as was found guilty and charged properly in count 1 with conspiring with others known and unknown. That's exactly what the evidence showed, and that's a reasonable inference for the jury to have drawn from the evidence in this case. If there are no further questions, I ask the court to affirm the appellant's conviction.
Thank you. Mr. Jackson?
The case is charged. It was about my client, Amy Davis, Carlos Benegas, and Cindy Davis. And conspicuously absent from government counsel's argument is any reference to Carlos Benegas or Cindy Davis. And now on appeal, the case has morphed into a case about Mr. Cabello and French. That says a whole lot. It's a different case now that we're defending against than it was at trial. With respect to the instructional error, I do want to discuss that for just a few moments. In the brief, I said that I believe that claim is subject to plain error review. Unfortunately, that's what I think we're stuck with. Defense counsel did request a multiple conspiracy instruction He did request Cindy Davis's name be included in that instruction 17, but he just didn't take that next step. He didn't lodge a formal objection to the instructions as given. Unfortunately, that's the law of the circuit. That's what we're stuck with on that. Even then, I still believe it's plain error. We have the Edwards case cited in the briefs, and there it says that when you have multiple conspiracies in play, it's error, it's reversible error, unless the court gives that multiple conspiracy instruction. And the only way around that
is if you give us examples of what multiple conspiracies you see here?
Oh, they're everywhere. We don't take any issue with, Miss Davis doesn't take any issue with her being cast as a drug dealer, for lack of a better term, or having those drugs in her vehicle. There's conspiracies in play with respect to Cabello and French, who testified as to being fronted
Cabello
drugs.
and French are conspiring with Davis, our defendant?
In the very general sense, their testimony was enough to establish a drug conspiracy, but not the one charged in count one.
Okay, any other conspiracies?
All these conspiracies in the other cases to which Ms. Davis pled guilty.
Was there evidence of that before the jury, these other cases?
That's hard to say, Your Honor. I guess there was with respect to French. He was charged in his own conspiracy case too, and he testified at length. I assume that his drug conspiracy case included this drug conduct. I mean, I don't really understand.
Well, are we limited to what the jury heard? I mean, I appreciate you looking at this in a very global manner, but I think we're restricted to the record here and what was presented to the jury.
Sure, the jury heard about drug conduct with Cabello and French. It just wasn't included within count one. And Your Honors, I'd respectfully request that the court reverse with respect to count one and remand to the district court to conduct further proceedings. Thank you.
Thank you. Thank you both for your arguments this morning. The case is submitted. Our third case for argument is Childers versus Crow. Good morning.
Good morning, Your Honor. May it please the court.
We are ready to hear from you, Mr. Pincus.
Thank you. May it please the court. My name is Howard Pincus from the Federal Public Defender, and I represent John Childers. Mr. Childers was convicted of 2 violations of Oklahoma's Sex Offender Registration Act, where one statute did not apply to him at all, and where his registration period had ended, so he could not be guilty of any SORA offense. This means that Mr. Childers is both actually innocent of the offenses, excusing his failure to file his habeas petition within the statute of limitations and any other procedural bar to relief, and that his convictions violate his federal due process right to be convicted only on proof of every element of each offense. Mr. Childers' innocence claim is based on an element of the offense or all elements of an offense not applying to him. Though claims of actual innocence typically involve new facts, this is also a claim of actual innocence. It's the same type of claim as in Bowsley versus United States, which involved the narrowing of an offense element and which the Supreme Court recognized could support a claim of factual innocence, citing habeas cases like Schlupp versus Dello. And this court in Prost versus Anderson also recognized that this is a type of factual and actual innocence claim. Oklahoma's law defines the reach of the state offenses. After Mr. Childers' convictions, the Oklahoma courts issued decisions involving whether provisions of SORA could be applied retroactively. In Starkey, the Oklahoma Supreme Court held the state's ex post facto clause prevented an extension of registration periods from being applied retroactively. It relied in significant part on the fact that this extended residency restrictions that it considered to be analogous to banishment. The Oklahoma Court of Civil Appeals later applied this to Section 590, of which Mr. Childers was convicted, involving residency restrictions, and held that under Starkey, it was clear that as a matter of Oklahoma ex post facto law, the residency restrictions could not be made more stringent after the offense of conviction in the underlying sex offense. At the time of Mr. Childers' 1999 SORA conviction for violating section, not his SORA conviction, his underlying sex offense conviction, Section 590 did not even exist. It was not enacted until 2003. Under Starkey and Graham, it could not apply to Mr. Childers at all.
And so you're saying actual innocence, that he is convicted of a crime that he could not be convicted of under ex post facto law, right?
Correct, Your Honor.
Oklahoma law. Is that the same argument that was raised before the district court?
Well, in the district court, the argument was more about the sentencing components of it. It was still based on Starkey and that line of cases. It's not precisely the issue. This court in its COA interpreted the petition liberally to include a claim analogous to the one we're making. We're making one that's slightly different. We're training it on
Isn't that a problem? I mean, there's a big difference between challenging the appropriate sentence and challenging whether the conviction itself was valid.
Well, there is, but actual innocence excuses habeas problems with going forward, like statute of limitations or procedural default. And things like procedural default are grounded in principles of comity and federalism. Same thing with the statute of limitations, which also goes to the finality, the state's interest in finality. Those interests are markedly weaker in the issue of whether this court considers something not raised in the federal district court. It doesn't involve any principles of comity or federalism. And the Supreme Court has recognized.
But doesn't it involve the baseline of what appellate courts do, and that is to review issues that are raised before the district court?
It does, but if actual innocence should excuse does excuse the failure to raise something in the state courts when you're challenging a state conviction, it should also excuse the failure to raise the precise issue in the federal district court.
Do you have any case that would help us resolve that point?
Just general principles of habeas law, like Engels versus Isaac, which indicate that the interests in the state procedural context are much stronger than the ones in the are much stronger. And here we're only dealing with respect to this court's relationship with the federal district court in terms of federal interests and not any independent state interests. And actual innocence should allow that to be overcome, just as it allows more weighty state interests in the habeas context, which are protected by numerous things like all the judge-made rules about procedural default, and also statutory things like the statute of limitations in EDPA. This court's general hesitancy to review things that were not presented in the district court are, of course, tempered in other ways, and it's just a judge-made rule. It's not anything that this court can't excuse based on a showing of actual innocence, which is what we have here. We have actual innocence based on a state statute that doesn't apply to Mr. Childers at all. He was proceeding pro se in the district court. He raised something analogous to this, and this court should excuse any defect.
So you would have us rule that the district court erred in not opining correctly on an issue that was not raised.
Well, the district court, remember, relied only on the failure to file within the statute of limitations. And we're not disputing that Mr. Childers did not file within the statute of limitations. Actual innocence is a way around that. And that's something that, as the state points out, is purely legal here. It's based on the ex post facto issue that we're raising that was raised in the district court, although in a slightly different way, and we're raising on appeal. And if, as a matter of Oklahoma ex post facto law, Section 590 did not apply to Mr. Childers at all, he's clearly actually innocent of that offense. He can't be guilty of an offense that just had no application to him. And
what about your claim, Mr. Pincus, on the residency provision? You've added that claim in your brief too, and I'm not sure how you can argue that claim's not been forfeited, because that's really not, it's an ex post facto claim, but it's nothing at all like what arguably was raised in his habeas petition.
Well, Mr. Childers in his habeas petition believed that that Section 590 applied to him and that it only had a 1-year maximum sentence. In fact, it didn't apply to him at all.
But where did he raise that argument? In fact, you seem to be conceding that he didn't raise it because he believed it applied to him. I don't see how you get there.
Well, he was relying on the effect of Oklahoma ex post facto decisions as to a sentence that he thought applied. And this is about whether the crime applied at all. It's still based on Starkey and Siniglia and the same cases that he cited in the federal district court. It is a different argument. It's not the same.
It's quite a different argument. It's quite a different argument.
And again, his actual innocence should excuse his pro se filing not containing this precise argument in the federal district court. It's something this court certainly can do. This court has said that it can consider these arguments forfeited or waived, but it also has the discretion not to. And actual innocence is a reason for it not to. And the Graham case shows very clearly that under Oklahoma ex post facto law, applying a more rigorous residency restriction can't be done consistent with Oklahoma ex post facto law. So applying a residency restriction at all certainly can't be. And this just did not exist at the time of his original sex offender conviction. So he's not guilty of it. He's actually innocent. And it's a federal due process violation for him to stand convicted of a crime where no elements of the offense can be shown because there was no offense that applies to him at all. He also, as to both offenses, the residency violation and the failure to update address, is actually innocent and entitled to habeas relief for a second reason. His convictions on both charges required that he actually be subject to SORA. And under Starkey and basic principles of ex post facto law under Oklahoma law, he was not. At the time of his sex offender conduct, back in 1992 and 93, SORA provided that a registration period was 10 years, but only 2 years upon completion of a DOC sex offender treatment program, which Mr. Childers did complete.
But
so
counsel, that was changed, and that act was changed in 1997, and that provision excusing that 2 years provision was omitted in 97. Your client was convicted in 99, so.
Well, that's correct. And the Oklahoma courts have said in cases like Starkey that that is the law in effect at the time of conviction that matters for Oklahoma ex post facto purposes. But that's inconsistent with basic Oklahoma ex post facto law. And in fact, in neither Starkey nor any other Oklahoma cases was it an issue of whether it should be at the time of the conviction or at the time of the act. Basic Oklahoma ex post facto law, like basic federal ex post facto law, looks to whether there is increase in punishment for an act or a fact that was already established. His acts, his sex offense crimes were in 1992 and 1993. At that time, he could have been subject to only a 2-year SORA registration requirement. That was changed to his detriment in 1997. And the same, under bedrock principles of Oklahoma ex post facto law, it's the increase from the time of his offense conduct that is what matters for ex post facto purposes.
But maybe in this particular area of registration for sex offenders, there is some logic in tying those registration requirements to the date of conviction for the underlying offense. You get what I'm saying? Otherwise, you're looking at it as a freestanding charge, which really would only be a charge if it is, again, connected to a prior sex offense.
Well, the time, the registration period always runs from some point after conviction, just like a penalty runs from conviction. It's his act, though, that subjects him to SORA. It's when he's convicted of the act that SORA actually comes into play, but it's his conduct in committing a sex offense that makes him a sex offender and that subjects him upon conviction to the Sex Offender Registration Act.
Do we know, counsel, do we know when he had sex offender treatment?
Well, he has alleged it in his petition that he had sex offender, that he completed the sex offender treatment program in prison.
But we don't know when, right?
Well, we know it was sometime before 2005 when he was released. It obviously was sometime between when he was convicted in 1999 and when he was released in 2005. And the appellee...
If it was after 1997 when that 2-year provision was omitted from the Oklahoma statute.
It surely was, and that's why we're saying that it has to run from the time of his sex offense under basic principles of Oklahoma law. And we'd ask this court to conclude that Mr. Childers is actually innocent, excusing any procedural barriers, and that it grant him habeas relief. Thank you.
Thank you. Mr. Finelli?
Thank you, Your Honor. May it please the court. My name is Joshua Finelli from the Oklahoma AG's office, appearing on behalf of respondent Scott Crow. Petitioner seeks to undermine 2 state court convictions based on purely legal challenges that are both untimely and unexhausted. This court should decline petitioner's invitation to explore the merits of his claims and should instead affirm the ruling of the Northern District of Oklahoma dismissing his habeas petition. No relief is warranted here for 2 key reasons. First and foremost, petitioner's claims are procedurally barred, and he's not shown his actual innocence sufficient to overcome those bars. And second, alternatively, even if this court were inclined to find that petitioner has raised a showing of actual innocence, this court should still remand the matter to the district court for further development of the record in the first instance below. Now, with the court's permission, I'd like to begin my argument, at least the first few minutes here.
What purpose would a remand? I didn't get that out of your brief. What purpose would a remand serve?
Your Honor, I think the purpose of a remand would be only if this court were to find that petitioner has raised a showing of actual innocence, inasmuch as this court would need to find that his ex post facto challenges raise ones of factual innocence. And here, petitioner's claims simply can't. So
that's why you would remand, because we're talking facts and not law, and we can't here look at whether or not the law would apply to this individual.
Your Honor, in this respect, if the court truly did find that petitioner has raised a showing of factual innocence, then I think the matter would need to be remanded below for consideration of the merits in the first instance. Because as the Supreme Court reasoned in Wood versus Milliard, absent an abuse of discretion, or absent extraordinary circumstances, a federal appellate court should deal with a case, whether procedurally or substantively, in the same fashion that was done so below. And so here, because the Northern District of Oklahoma time-barred petitioner without considering the merits of his claims, if this court truly were inclined to find that he's raised a claim of actual innocence, in as much as he'd have to show his factual innocence, then this court should remand the matter. But I don't think the court needs to even go that far, because petitioner here today has not shown anything more than legal insufficiency. Now, we know McQuiggan v. Perkins, the U.S. Supreme Court, cautioned that tenable actual innocence gateway pleas are rare. Indeed, under the Schlupp framework, it's only in the extraordinary circumstance where a petitioner has shown his actual innocence as a gateway to otherwise procedurally barred claims.
Why doesn't this fit the framework of Bowsley?
Your Honor, two responses. I'm sorry, Your Honor.
I think McQuiggan even cited Bowsley as an example of an actual innocence claim. And this seems to fit Bowsley's structure, at least.
Your Honor, my response to the Supreme Court's decision in Bowsley is at least twofold here. First, although the U.S. Supreme Court did mention Bowsley in its reasoning in McQuiggan, the Supreme Court has consistently reaffirmed, following Bowsley in McQuiggan in 2013, as well as in House v. Bell, which was in 2006, that a petitioner does need to come forth with evidence of new reliable claims showing his innocence. But even if this court were inclined to find that Bowsley in some way is applicable to the instant facts, Bowsley considered an intervening change of law. In that case, there was an intervening decision that changed the use of a firearm test under federal law, and the Supreme Court remanded the matter to further develop the record on that issue. But petitioner here can't avail himself of the reasoning in Bowsley, because we don't have an intervening change of law here. So even if Bowsley stood for the proposition that actual innocence can be based on an intervening change of law, we don't have that here. And in fact—
Well, isn't that the whole point, though, of counsel's argument, that there is a change in law? And as a result, ex post facto applies, and he is being held accountable on charges that do not apply to him.
Well, Your Honor, with respect to the petitioner's allegation of an intervening change of law, I think that this court's order granting COA even recognized, and that's the order at page 6, recognized that petitioner could have brought his claims long ago, in the same sense that the petitioner in Starkey brought his claims in the first instance. It's based on a matter of statutory interpretation. So to the extent that petitioner sees this as an intervening change of law as a reason to excuse the procedural impediments, we simply don't have that here. Petitioner is raising the same claims that he could have raised at the time of his direct appeal in 2010. And so to that end, and this court has recognized that ex post facto challenges amount to ones of they're questions of pure law, essentially. And this court recognized that in the unpublished decision of Martin versus Ray, which is a case I discussed in my brief. And there, this court declined to allow a COA on ex post facto challenges when the petitioner there was procedurally barred. He was unexhausted in that instance. And the court there reasoned that the petitioner had not even come close to showing actual innocence because he had asserted merely legal challenges without in any way undermining the factual circumstances at issue there. The same was said by the district court for the District of Colorado in Peete versus Ramish, which perhaps even more pointedly addressed an ex post facto challenge. And there, the petitioner, the crimes that he was convicted of had even, the acts that were alleged to have occurred had even partially predated the statute he was convicted under. And that was a prototypical ex post facto challenge. And the district court below said that that did not amount to a showing of actual innocence under the Schlupp and McQuiggan framework. And therefore, he was not able to show actual innocence.
You're relying here on untimeliness and unexhausted. Is that it?
That's correct.
What you're relying on?
That's correct, Your Honor.
And doesn't actual innocence trump both of those?
It would, Your Honor, if petitioner were able to come forth with a credible showing of actual innocence and not mere legal insufficiency here. And petitioner's challenges offering that sort of prototypical pure question of law are not sufficient to overcome the procedural impediments that are at play here in this case. And so because petitioner is not only untimely, as the district court found below, but petitioner's claims are also unexhausted, as he's not first fairly presented them in state court, but would now be subject to an anticipatory bar if he returned. And I think this goes to Judge Briscoe's question to petitioner's argument in the first instance. These sorts of challenges weren't raised below. And not only were they not raised in state court, they also weren't raised in the federal district court below. And so
what do you say to counsel's argument that, well, surely if actual innocence can trump all of these concerns that we would have in issues of comity, surely actual innocence could trump waiver?
Well, Your Honor, my response to a petitioner's argument in that respect is the case at bar today does not share the same concerns that the petitioners had in McQuiggan as well as in Bowsley, because there we either have new reliable evidence, as was in the instance of McQuiggan, House v. Bell, or Schlupp v. Dello, or in Bowsley, this intervening change of law, a subsequent amendment to the law. We don't have that here. Petitioner is just raising legal challenges that could have been brought a long time ago. And so
why don't we have that? I mean, we have, if Mr. Pincus' argument is correct, we have a petitioner who wasn't subject to SORA at the time of his convictions, and he arguably didn't have to register at all. He wasn't registered at the time, so he's not subject to SORA, which is an element of a SORA offense. Why isn't this the same?
So, Your Honor, my response to petitioner's claim there is he's looking at matters that are simply undeveloped by the record below. And so, because
once we get those developed, if we remand to the trial court, he did assert in his petition that he had completed the treatment. That was asserted in connection with count one of his petition, where what he called count one, where he discussed the ex post facto argument. So wouldn't it be easy enough to get this back down to the district court and find out if he completed that treatment? Wouldn't that be easy enough to do?
Well, respectfully, no, Your Honor. And to that end, I think that even if this issue were remanded to the district court, I think these matters are so purely wrapped up in Oklahoma state law that upon a remand, I think the district court might have to provide or present a certified question of law to the Oklahoma Court of Criminal Appeals. And I understand that petitioner's argument here today is based primarily on Starkey and Cerniglia decisions from the Oklahoma Supreme Court, as well as a Graham versus Carrington Place Properties Association, which is from the Court of Civil Appeals and Intermediary Appellate Court in Oklahoma. But petitioner so much as acknowledges in his supplemental opening brief that we don't have a clear answer from the Court of Criminal Appeals. And to that end, had petitioner raised these claims fairly in state court, we might have that answer here today. The court wouldn't be forced to guess at questions of state law that were undeveloped in the record below. And so
I did want to ask you, it seems to me you didn't really make any argument in your brief as to whether you could interpret Starkey and the other case, and Graham, and the third case, Cerniglia. You didn't make any argument about that. Have you waived that if we decide we can reach that?
Well, I certainly would hope that I haven't waived that argument, Your Honor. And I think that the procedural grounds are strong in this case, and that's why I stood mostly on procedure in my brief.
What if we disagree? Where do we go then? We don't really have any briefing from you on what is a fairly complex issue.
I think, Your Honor, if you disagree with me on procedure, and even if this court were inclined to find that he has made a showing of actual innocence, I still don't think the record as it stands now is adequately developed enough to even bear out petitioner's claims on the merits. And so to that end, and I think with respect to Starkey and Graham, admittedly, a case like Graham, at first blush, it seems like it's on point in this circumstance, but the fact remains that it was issued by the Court of Civil Appeals, and we don't have an answer from the Court of Criminal Appeals. And so
I don't know why we need to remand for obtaining more facts. Don't we have the guidance of the timeline of when these acts occurred, when he was convicted, when the statutes were effective, when they were revised? We know all that.
That's correct, Your Honor. And so we do know the timeline in the record, but there aren't necessarily documents in the record that substantiate petitioner's claims. And I think this is to Judge Seymour.
Like what?
So, for example, any evidence in the record other than petitioner's own self-serving statement that he completed the program while in the custody of the Department of Corrections.
Have you ever challenged that fact?
Well, Your Honor, we haven't challenged that fact in the sense that that claim was not raised in the proceedings below. This is a new claim here today. And so, and in my brief before this court, I certainly mentioned the fact that the only evidence that he had completed that program is his own statement in the record on appeal, which is in his post-conviction pleadings. That's the record at page 9. And so to that end, all we have in the existing appellate record is petitioner's own self-serving statement that he completed that program. And so in that sense, because this claim wasn't fairly presented below, it certainly wasn't presented in state court, and it wasn't presented in the federal district court below, the record in this case is woefully underdeveloped. And so a petitioner is seeking to rely on the gaps in the record here to sort of to invite this court to speculate and conjecture, not only on matters of unsettled Oklahoma state law, as in the retroactivity of Oklahoma's SORA, but also as to the factual matters in the record regarding his alleged completion of the program, the DOC treatment program, during his time incarcerated. Also, what's unclear in the record is what his dates of reincarceration were following his release from confinement. Petitioner admits in his supplemental opening brief that this could be a possible wrinkle. It's not just a possible wrinkle. By statute, under Oklahoma law, the Sex Offender Registry Act does not apply to individuals while incarcerated. And so once again, the court is left to speculate as to what his dates of reincarceration were, even if he had completed that treatment program as he alleges in his post-conviction pleadings below.
Well, if we were to conclude that he is legally, factually, and all other ways innocent, can we reach that issue, or has it been waived?
As I understand your question, Your Honor, you're asking if the court finds he is actually innocent, can we reach the question of his duty to register? That would be his second ground in his brief.
Can we look at either conviction and look at whether or not the convictions were valid, or must we impose waiver? And if we have to impose waiver, tell me why.
Well, respectfully, Your Honor, I think even if this court were inclined to approach that issue, I think there are significant roadblocks to consideration of the actual substance of petitioner's claims. First, as to his Section 590 ground, living within 2,000 feet of a school, as I said, it depends on unsettled matters under Oklahoma state law. And as to his second ground, the duty to register that goes to both convictions, I think that depends largely on facts that are completely...
Just answer my question, hypothetically. If we say he's actually innocent, isn't that something that we can reach, even though he's not raised it before the federal district court?
Your Honor, I see that I'm just about out of time.
Go ahead, please answer.
Yes, and so if this court truly did find that petitioner has overcome the procedural impediments here today, I still don't think that petitioner's claims are cognizable here today. I think that he's waived them, he's forfeited them by not raising them below, and I don't think this court should even approach the substance of his claims in the first instance. And so for these reasons, we'd ask you to affirm the district court.
Do you have any case where you have an actually innocent defendant that where we cannot reach the issue because of waiver?
Well, Your Honor, my understanding is typically in the actual innocence context, as I noted at the forefront of my argument, a petitioner has come forth with new reliable evidence, and they've developed that in the record. And we don't have that here today because petitioner is raising merely legal and unpreserved claims that have never been heard before.
Thank you.
So in that sense, Your Honor, that portion is unclear. Thank you.
23 seconds.
23 seconds. I'll be brief, obviously. The fact that this could have been raised earlier in the Oklahoma courts, that's cause and prejudice. That was Bowsley. Bowsley shows that this is actual innocence. The appellee talks about how there's not proof that Mr. Childers completed the program. They represent, or the appellee is the director of the Department of Corrections, and they know that he completed this, or they know whether he completed this. And lastly, we've explained in our briefs why any reincarceration doesn't toll or restart the clock. There's nothing in the statute that suggests it does, and it's an obvious thing that would have been addressed in the statute if that were the case. There are no facts here that need to be developed. We know that it's all a question of when he was released, when his offenses were committed, or when he was charged, when the underlying conduct for which he was tried or charged with the SORA violations occurred. Thank you.
Thank you. Thank you, counsel. Thank you for your arguments this morning. Case is submitted. At this time, the court will take a 10-minute recess, and when we return, we'll hear arguments in United States versus McGee.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Good morning, Your Honor. My name is Susan Champion, and I'm here on behalf of my client, Malcolm McGee, who's currently serving a mandatory life sentence for a nonviolent drug crime. He's already served over 2 decades in prison for this nonviolent drug crime. And as noted by the court below, there's no question that Mr. McGee's sentence would be substantially lower were he sentenced today. But the question here is whether a court is strictly bound by the sentencing guidelines commentary in section 1B1.13 when considering a petition for release under section 3582. We respectfully submit that they are not strictly bound by these guidelines, and in accord with Judge Briscoe's recent concurrence in Rodriguez, we urge this court to follow all the other circuits that have addressed this issue and to remand this case to the district court for consideration on the merits. Last year, after exhausting other remedies, Mr. McGee filed a petition for compassionate release under 18 U.S.C. 3582 in the Northern District of Oklahoma. And he was able to file this petition thanks to Congress's expansion of section 3582, which now allows individual defendants to file petitions for compassionate relief directly to the court, rather than having to wait for BOP to do so. The court below denied relief for Mr. McGee on the ground that because Congress had not explicitly made the amendments to the section under which he was sentenced retroactive, reducing his sentence would usurp Congress's power. However, multiple courts have rejected this rationale and have used amended section 3582 to review defendant-initiated motions for compassionate release and to apply the sentencing factors articulated in section 3553.
What do we do with the policy statement? Do we apply it at all? Do we use it as a guideline?
So courts have approached this in multiple ways. As I said, all the circuits and a majority of district courts have all agreed that they can use this section for extraordinary and compelling circumstances. We argue that the guidelines do not apply. The guidelines specifically reference BOP-initiated motions for compassionate release, and therefore the extraordinary and compelling circumstances are now in the hands of the courts to make those decisions when a defendant is able to directly appeal to the court.
But don't we have the statute that mandated the Sentencing Commission to issue new guidelines to follow on with this new First Step Act? So don't we have some indication, at least from Congress, that we should pay some attention to the Sentencing Commission?
So what I would argue here is that we need to look at the intent of bringing this expansion forward. Congress specifically wanted to expand the use of compassionate release and has instructed the courts to make those determinations. The guidelines themselves, as we assert, do not apply to defendant-initiated motions, and that does not mean that courts should sit on their hands while waiting for the Sentencing Commission to amend guidelines. Courts have and do use their discretion to grant these petitions based on a consideration of the merits of the case.
Well, when you're using that discretion as a district court, couldn't you sort of noodle through the policy statement and say, well, that's a good thing to think about. I'll think about that. And here's some other things.
Certainly some courts have done that, and that is purely within the district court's discretion to consider whatever guidelines they might find valuable in making that assessment. But again, we argue that—
Isn't that the problem though, counsel, is that it's purely in their discretion whether to look at the guidelines or look at the policy statement. They can if they want, they don't have to. How would we then review the district court's actions for an abuse of discretion? What are we reviewing?
So many courts below have certainly made determinations that, individuals that make these motions have a variety of extraordinary and compelling reasons. And so long as the court is able to articulate those, it is certainly within the appellate court's purview to consider whether those articulated reasons meet the standard.
Well, that's pretty subjective, perhaps what each district judge might feel is compelling or extraordinary, and their level of compassion. I mean, you see what I'm saying? How do we review whatever their reasons are for granting or not granting, or for not granting? I'm sorry.
Of course, and I understand the
That's
issue.
the problem I see it as, is what arguably that is unfettered discretion, and that's not what Congress intended.
Well, what we do know is that Congress intended for an expansion of the use of this, that they felt that it was not being used appropriately. What we do know is that in 1984, when Congress was discussing these issues, they themselves said that this can and should be used to consider unusually long sentences and other factors. And they did leave it quite open in terms of what factors courts could consider. So our argument then is no different from other situations in which a court makes a determination based on articulated factors about whether somebody meets the extraordinary and compelling circumstances. And then it would be an abuse of discretion argument to the appellate court. And appellate courts have been able to address those on a case-by-case basis as necessary.
So you're analogizing these types of cases, motions to reduce cases, with just a straight sentencing, where the district court now, after Booker et al., can now exercise its own discretion to go and do whatever it wants, regardless of the guidelines.
Yes, Your Honor.
So as Judge Moritz says, unfettered discretion. We have opened the floodgates.
And what I will argue is that the floodgates are not necessarily open. Petitioners are able to present their compelling case, their extraordinary circumstances, and district courts will have the opportunity to review them and make a determination of whether that case is sufficient, whether the case made by the petitioner is sufficient. Multiple courts have been addressing petitions like this, and there does not appear to be a deluge, an unmanageable deluge for the court to address these types of petitions. And again, it's important to focus on the origin and intent of this expansion. Congress felt that not enough of these petitions were being brought to courts, and that petitioners should be able to take advantage of this particular avenue of relief, and granted them that opportunity.
So what relief are you seeking from us?
We are asking that this court remand this case back to the district court for a review of the merits. Again, there's no question Mr. McGee is serving a life sentence for a completely nonviolent drug crime. He's been in prison for 20 years and has a spotless record. There are multiple factors related to Mr. McGee that fit squarely within reasons for considering seriously a petition for compassionate release. There are 3 particular changes in law that would mandate that he not be subject to a mandatory life sentence. And his disciplinary record is almost spotless. He has strong family ties. He is positioned for success in the community. There are multiple reasons that the district court should consider these merits and make a determination. And that's all we're asking, Your Honor. We're just asking that the district court have the opportunity to review the case fully on the merits.
Do we apply the policy statements of the Bureau of Prisons?
Well, our argument is no. That is a Bureau of Prisons policy statement. Petitions brought under 3582 directly by a defendant now lie within the court's jurisdiction, the court's authority to make those determinations and to use whatever factors they consider relevant to that determination, including the sentencing factors articulated in 3553.
What's your best case that would allow us to rule in your favor?
Well, I would point to Mau, which I believe was recently argued and was,
Any appellate court ruling?
Yes. It was recently argued in the appellate court.
No, I know. I'm on the panel.
Right.
Any ruling from an appellate court?
Any ruling from an appellate court? So there are multiple rulings. The Second Circuit, I believe Brooker in the second. The Fourth Circuit.
So of these cases where we have a circuit court ruling, what's the best case?
The best case is going to be Brooker from the Second Circuit, which holds that 1B 1.13 is not applicable to 3852 motions filed by defendants. And also I would say United States v. Gunn from the Seventh Circuit, which states that the guidelines manual lacks an applicable policy statement covering prison-initiated applications, and that because of that, it does not curtail a district judge's discretion, because any decision is consistent with a non-existent policy statement.
Say that last part again, because any, what?
Because any decision is consistent with a non-existent policy statement. And then I would also point to United States v. McCoy out of the Fourth Circuit. And then finally, United States v. Jones in the Sixth Circuit.
Did any of those courts describe what they think should guide the court's discretion? Should it look to the policy statement and essentially substitute the court for the Bureau of Prisons?
So in those cases, the court basically, the appellate court said that the statements don't apply. They basically argue and are in line with Jones, which says that district courts have full discretion to define what extraordinary and compelling reasons are without consulting the policy statement. Again, because it's discretionary, I'm not going to say that a court can't look at something because it is within the court's authority to consider whatever the court thinks is relevant. However, I think all of these cases very strongly reject the proposal that a court is bound by these guidelines. And if there are no further questions, I'll save my time for rebuttal.
Thank you.
Thank you.
We're ready to hear from the government.
May it please the court. My name is Lena Alam. I represent the United States. I'd like to first begin by apologizing for a rather glaring error in my brief. On page 3, I say that on remand, originally, the district court resentenced Mr. McGee to 96 years on count 3 of the indictment. Rather, he decreased the sentence to 96 months. I'm sorry, that was a pure oversight. Next, I'd like to talk a little bit about the standard of review because there's a fundamental disagreement in the parties' briefs. And the reason for that is this. Our view of Judge Egan's order in this case is that she, in denying Mr. McGee's motion, exercised her discretion, recognizing that she could have found that Congress's changes in Section 401 provided an extraordinary and compelling reason under the other reasons provision of Note 1D to 1B 1.13 to reduce Mr. McGee's sentence, but that she found that it was inappropriate to do so because doing so would usurp Congress's authority. And so for that reason, because Judge Egan's order, and this is, I believe, at pages 75 and 76 of the appellate's appendix, because that order displays Judge Egan's exercise of that discretion that she believes she has to determine what types of reasons are extraordinary and compelling, that this case, unlike the Mamau case currently before the court, doesn't provide a vehicle to make the determination of whether, in the first instance, district courts have that discretion. So
I thought that she refused to rule in favor or consider this even because I thought her statement was she lacked authority. And if that's her statement, isn't that a legal conclusion? That's not an abuse of discretion question.
Judge Egan did not say that she lacked the authority to do so in her reasoning. What she said was that Congress chose not to make Section 401 retroactive, and that to utilize the other reasons commentary under 1B 1.3 and 3582 instead, as to get the same result, would usurp the power given exclusively to Congress.
In other words, she has no authority.
That's wrong. I mean, the power given exclusively to Congress that she references there is the power to make that a 401 retroactive. The reason that reveals an exercise of her discretion under 1B 1.13, applying the Sentencing Commission's policy statement, is because she is not deferring to, under 1D, the director of the Bureau of Prisons. Her deference here is to the original decision by Congress in enacting 401, Section 401 of the First Step Act, to not make that provision retroactive. She is not there talking about the power delegated by Congress to the Sentencing Commission and then by the Sentencing Commission to the director of the Bureau of Prisons.
All right. Well, if I think I understand what you're saying, and I'm not sure I did understand your argument before, but if that's what you're saying, why didn't she abuse her discretion then? If she actually did exercise her discretion, why wasn't that an abuse of discretion to believe that she could not find that an extraordinary and compelling reason under 3582 C1A, when really there's nothing to guide her discretion if we agree with Appellant here?
There is something to, well, if you agreed with Appellant here, the guidance of the court's discretion would be, at least in part, in 1B 1.13 as not binding, but as providing background. The difference, I think, here between how we think Judge Egan exercised her discretion and how Appellant would have this court give all district courts discretion is that here Judge Egan, in reading subsection 1D, recognized that the court had or exercised discretion under that specific provision to define other reasons. She did not read 1B 1.13 out entirely. She did not find it inapplicable. In fact, in the following sentence of her order, she says, further, there are no other factors cited by the defendant that correspond with the requirements specified by the Sentencing Commission to define extraordinary and compelling circumstances under 1A through C. And
wasn't that an error? Wasn't that an error, though, for the court to believe that she needed to apply 1D or decide whether there were other factors? Because if that doesn't constrain her, wasn't that an error all by itself?
If the court accepts Appellant's position that 1.13 is not applicable, then that does not mean the district court can't consider those factors in exercising her discretion.
But we don't know if that's what she did here. It seems to me that the way she worded this one paragraph order is she believed that those factors absolutely did constrain her. because then she goes on to say, further, there are no other factors cited by defendant that correspond with the requirements specified by the Sentencing Commission to define extraordinary and compelling reasons. And then, so she seems to be referring to the policy statement here. And she seems to believe that it guides her. And I'm saying, was that an abuse of discretion, since if we agree with the defendant here, that it doesn't apply?
And to the extent that she correctly identifies that the provision under which, she had discretion to consider reasons that go beyond 1A through C under the other provision, other reasons provision of 1D, then it was nonetheless not an error, an abuse of her discretion, because she recognized that she had the discretion to go beyond the 3 reasons in 1A through C, and that to define for herself what reasons would qualify under the other reasons provision, not constrained by the reasons identified by the Director of the Bureau of Prisons, or indeed by the Sentencing Commission. Because the use of the retroactive use of the non-retroactive provision in 401 would clearly be outside of the reasons that had been given by either the Sentencing Commission or in the Bureau of Prisons policy statement. And so by considering that as a reason that she might have used under the other reasons provision, Judge Egan revealed that she was at least considering her discretion to find other reasons apart from those reasons that the Sentencing Commission and the Director of the Bureau of Prisons had identified.
So if she denied this motion on the merits, which is what you're saying she did?
Yes.
What was her reasoning? What was her support for denying it?
That Mr. McGee's situation was not sufficiently extraordinary and compelling to warrant sentencing relief, to warrant a sentencing reduction here. And in doing so, Judge Egan was vindicating the congressional intent, both of the Congress that initially judged that an appropriate punishment for Mr. McGee's crime at the time, that is trafficking more than 6 kilograms of PCP after 2 prior drug felony convictions, was mandatory life. She was also vindicating the congressional judgment in the First Step Act, which was that although some defendants going forward for that type of offense with those prior felonies would not merit a life sentence, Congress chose not to make that change retroactively applicable precisely to defendants like Mr. McGee. And that reason, I think, underpins our other point, which, of course, as you know, the Second, Fourth, Sixth, and Seventh Circuits have disagreed with, but that the sentencing reduction provision in 3582C1A cannot be read so broadly as to allow district courts to undermine congressional intent, not just in requiring that the Sentencing Commission, not district courts, describe what constitutes, what types of factors may be considered as extraordinary and compelling, but those congressional determinations in the first instance about what kinds of sentences, mandatory sentences, are required under certain circumstances. To read 3582C1A as broadly as the Second, Fourth, Sixth, and Seventh Circuits have is to completely undercut congressional intent in imposing mandatory minimum sentences, and to allow courts unfettered discretion, as we've discussed, to reduce sentences in any event. And going back to Judge Briscoe's question earlier, the full sentencing discretion that reading 1B 1.13 out of the guidelines would confer would be consistent with original sentences. And it is clear from the language in the Sentencing Reform Act, from the legislative history of the Sentencing Reform Act, that in adopting 3582C as a sentence reduction provision, that provision was not meant to confer full sentencing discretion. That sentencing modification procedures under 3582C were meant to be something less than a full resentencing. And
well, you've talked a lot about congressional intent, but we also have to put on the scale the congressional intent behind the passage of the First Step Act, which was to increase the number of inmates released for under compassionate release provision.
And absolutely, and the change that they actually made to the provisions of 3582C1A have had precisely that effect. As the court heard in the Mau Mau argument, compassionate release motions have gone up dramatically, as have compassionate release grants, because Congress's intent wasn't to change the standards to be applied in granting compassionate release, it was to change the gatekeeper. And the difference here is in the prefatory language to 1B1.13 and in 3582C, or in 1B1.13 and 3582C, referring to a motion by the director of the Bureau of Prisons, and in subsection 4 of the commentary, that is what was changed in the First Step Act, who the gatekeeper was. What specifically wasn't changed in the First Step Act was what standards would be applied once those motions were filed. And the effect that Congress sought in expanding the availability of relief under the compassionate release statute has already been achieved by avoiding the problem of the director of the Bureau of Prisons not filing motions in the first instance where defendants were plainly eligible for compassionate release. Now that defendants can file those motions for themselves, they are able to get access to the courts, and the court can grant those motions. The
point, I think, becomes, as we narrow this down, the point becomes, as regards your gatekeeper, and if it's the district court, must the district court look at 1.1b, the guideline?
1B 1.13, 1D, the other reasons? Yes. And
1B1, the sentencing guideline, must it look at that, which is what the district court did here?
The district court did look at 1B 1.13 here, and in fact, yes, courts must continue to look at 1B 1.13, which is the applicable policy statement, because Congress told them they must.
And Congress didn't say that. Congress didn't say that. Congress said, and that's such a reduction, which is for extraordinary and compelling reasons, and this is 3582, and that such a reduction is consistent with applicable policy statements. That's what Congress said. And what possibly could make this applicable when it opens up with the lines upon motion by the director of the Bureau of Prisons? I don't understand how you can say that Congress intended that existing policy statement, which doesn't apply, fits those clear words.
Well, saying it doesn't apply begs the question somewhat. The reason it remains applicable is because the Sentencing Commission adopted that, and in fact, the title of 1B 1.13 shows that it is the policy statement the Sentencing Commission intended to apply to 3582C1A, and it remains applicable even if it must be read to incorporate the addition of the gatekeeper, because the language at the beginning, I see my time is up. May I finish my answer?
Go ahead, please.
The language, the addition of another gatekeeper, of someone else who could file a motion to the statute, should be read into the first paragraph of 1B 1.13, because that language is nearly identical to the statute. And so it does not implement the congressional directive under 994T, 28 U.S.C. 994T. Really, the purpose for that policy statement was to set standards, not to identify the gatekeeper. So Congress delegated to the Sentencing Commission the ability to set standards for what constitutes extraordinary and compelling circumstances, not to identify who gets to file the motion in the first instance. And so when Congress changed who gets to file the motion in the first instance, that change can easily be applied. And the fact that that particular sentence of the guideline is no longer consistent doesn't matter, because that's not the part of the guideline that Congress directed the Sentencing Commission to adopt. And those parts where the Sentencing Commission fulfills its congressional mandate to set a standard.
Well, it hasn't fulfilled the congressional mandate. The congressional mandate is to pass and create policy statements that are applicable to the First Step Act. And they have not done that because they don't have a quorum. And so we're left in this netherland.
The government believes that the policy statement can be read to still provide the standards that apply, even though the gatekeeper has changed.
Thank you. Thank you, counsel. We have your argument. Rebuttal?
You're on mute.
Apologies. I would just refer the court to the title of the amendment, which is to increase and expand, increase the use and transparency of compassionate release. That was congressional intent. Multiple reforms to the laws have also expressed congressional belief that these extreme sentences for particularly clients like mine, Mr. McGee, completely nonviolent offender, are too harsh. And Congress's change to 3852 or 3582 was specifically in recognition of the fact that not enough individuals were being brought to the courts for consideration of compassionate release. And this offers the courts an opportunity to use their discretion to do so. I just want to stress, for example, that many circuits and district courts have been providing this sort of relief. They have found that they have discretion, and many individuals with perhaps more serious offenses and who have served far less time than my client have been able to take advantage of this relief. And I would just urge the court to follow the other circuits and the majority of district courts by allowing Mr. McGee to present his compelling and extraordinary case to the district court for consideration on the merits.
Thank you. Thank you, counsel. Thank you both for your arguments this morning. The case is submitted.
Thank you.
Our next case for argument is United States versus Kilgore. And we are ready to hear from the appellant.
Detective Jennings sought authority from the magistrate to search the defendant's residence for evidence of child pornography. Detective Jennings defined the term child pornography in the affidavit as images of children engaged in sexually explicit conduct. Detective Jennings provided the magistrate with a number of examples of exactly the type of conduct that would fall in the category of child pornography. And yet in the probable cause portion of the affidavit, Detective Jennings describes the two images that were uploaded and intercepted as child exploitation materials. Detective Jennings is an experienced officer. She works in the cyber crimes unit, the unit that investigates sex crimes like this one. And the only inference that we can draw from the fact that she used the term child exploitation materials rather than child pornography, given that she understood its legal meaning, is that the two images intercepted were other than child pornography. We know from yes.
Doesn't the affidavit relates that she's working jointly with the Homeland Security Commission, and federal law recognizes that child exploitation is the same as child pornography, doesn't it?
I'm not entirely willing to concede that issue. I think what the government said was that in, I think it's Chapter 211, Title 34, Section 21-111, the term child exploitation materials were defined to include child pornography. However, we know from we know from that statute that I think the phrase is, in this chapter, the following definitions apply. From that, we conclude that outside that chapter, those definitions don't apply. So Mr. Kilgore was convicted of an offense in Chapter 110, the National Strategy for Child Exploitation, Prevention, and Interdiction is, I believe, 211. So what we would argue is that, at least as it pertains to Mr. Kilgore's offense of conviction, the term child exploitation material has no legal meaning. We can't conclude from the phrase child exploitation materials that the images are in any way sexually related or in any way involve sexual conduct. We certainly can't conclude from that phrase that the images intercepted were illegal to possess. The district court concluded, well, I guess the first thing I would say is, so we have two images. We don't know what they are of because they're not described. We have a phrase that's not defined. The district court, well, the question would be, how much weight do we give those in the totality of the circumstances? The district court gave it substantial weight because the district court came to the conclusion that the phrase child exploitation materials and child pornography are interchangeable or synonymous. Again, we don't find meaningful or compelling support for that assertion. Even assuming that that assertion is correct, the real question is whether that information was before the magistrate. We know that fact was not contained in the affidavit. We have no reason to believe that that information was conveyed orally to the magistrate during the application process.
Yes. Counsel, I'm sorry. Weren't there different aspects of the affidavit that we could look to to assume that the magistrate could certainly infer that we were talking about child pornography here? And one thing in particular is the fact that he had the affidavit recited that he had the prior child pornography offense and that he was a registered sex offender, and it implied a current registered sex offender, not a past registered offender. Why wouldn't that be fairly strong, a fairly strong inference that we are talking about child pornography images here, if the term itself isn't enough?
All right. So the first thing I would say would be that the fact that Mr. Kilgore has this prior conviction is in itself not dispositive.
Understand? I'm looking at it overall. I'm talking about the overall affidavit.
All right. So since it's not dispositive in and of itself, we would have to assess it some weight, some value. What we know is that recent convictions are more valuable than older convictions.
I'm not really talking about the value of the conviction itself. I'm talking about whether we could infer from some of the language that's included in the affidavit that we're talking about child pornography images here.
I don't think that we can make that inference. I don't think that we can make the inference that the images were in any way illegal to possess. I think the best we can do with the information we have is to realize that Detective Jennings knew exactly what child pornography was, its legal definition. She chose not to use that term in describing the images that were recovered. She chose not to describe the images that were recovered to avoid just this problem. And so the fact that Mr. Kilgore has a prior conviction is just one more thing to consider. We would give it more weight if it was a recent conviction, less weight if it was an older conviction. We can't determine from the affidavit whether it's a recent conviction or an older conviction. We do know that he is still a registered sex offender. The government felt that was important. They looked at Perrine, I think it was, where the defendant was still on probation, and from the fact that he was still on probation, they inferred that it must be a relatively recent conviction. However, this isn't probation. This is a SORNA registry. Many, possibly most people who register under SORNA maybe lifetime registration. So given that SORNA has a lifetime registration possibility, it is much more difficult to make the inference that this is a relatively recent and therefore more valuable in our assessment conviction. So we have the two images. We're not sure what they're of. We're not sure whether they involve anything sexual. We're not sure that they're even illegal. We have a conviction that may be 30 years old. It may be 30 days old. We don't know. It's hard to assess value in that circumstance. We know that photo DNA was used to determine that they were child exploitation materials, which, because it's the same term, doesn't take us much further down the road in determining what exactly child exploitation materials are. And so that's the totality of the information the magistrate had before him or her to make a determination as to whether evidence of a crime would be found in Mr. Kilgore's second address, which he wasn't living in when these two images were uploaded.
And can you have child exploitation that is legal?
Well, we're not talking about child exploitation. We're talking about images of child exploitation.
Okay.
So child exploitation.
Can you have images of child exploitation that are legal?
I think we certainly could. For instance, child exploitation encompasses transporting a minor for an illegal reason, for instance, prostitution. So if you had an image of a minor child being transported, you uploaded that image of a minor child being transported, that would certainly not be an illegal image to possess, upload, distribute. So the answer is yes. Judge Frizzell gave substantial weight to the term child exploitation material, known images of child exploitation material, because based on his experience, his training, his special knowledge, he believed that those known images related to a government database that stored child pornography. And so he concluded that the images that were uploaded could not have been other than child pornography. Again, that may or may not be correct. We don't find any support for that in the government's answer brief. Even if it is correct, the real question again is, was that information before the magistrate? And what we know is that that information was not in the affidavit. Again, we have no reason to believe that that information was conveyed orally to the magistrate. Those facts don't appear to be common sense inference type facts. What they appear to be is knowledge that, if correct, comes from specialized training, not something that we can just infer from a reading of the affidavit. So what we ultimately would say is that the fact that two images were uploaded over the course of 2 months, given that we don't know what those two images were, given that we don't have any definition or meaningful definition for child exploitation material, given that the magistrate wasn't provided with any information to allow him to make those determinations, given the age of the conviction, we just don't see a minimally sufficient nexus between the illegal activity, if there was illegal activity, the uploading, and the place to be searched, which was a residence from which those images were not uploaded. Because a minimally sufficient nexus doesn't exist, then the good faith under Leon wouldn't apply to this case, and we would be limited to examining whether there was a substantial basis for determining that probable cause exists. And again, it seems a stretch to consider two images, again, that we don't know what they are of. We don't know that they're sexual in nature. We don't know that they're illegal to possess, along with a prior conviction that may be decades old for all we know, to lead us to search a house in which no criminal activity was known to have taken place. So if there's no more questions, I would save the remainder of my argument for rebuttal.
Thank you.
May it please the court, my name is Chantel Dial, and I represent the United States.
This court should affirm the district court's denial of Mr. Kilgore's motion to suppress for 2 reasons. First, the search warrant was supported by probable cause. And second, even if this court determines there wasn't probable cause, the executing officers reasonably and in good faith relied on a neutral magistrate's decision. I want to start with some of the questions that your honors raised. The first was, isn't child exploitation child pornography? Ultimately, this court doesn't have to determine that answer. What we're looking at here, as defense counsel mentioned, is the totality of the circumstances. And the defendant relies quite heavily on the fact that these images were not known. It's 2 unknown images that just were child exploitation. This is significantly different from an Edwards that the defendant relies on heavily in his brief, because in Edwards, the court noted that there was no uncertainty regarding the content of the images that the defendant had posted. Here, perhaps there is uncertainty. Perhaps the issuing judge doesn't know for certain that these images of child exploitation are images of child pornography. But that goes then to the second question raised by your honors. Can we infer from the language in the affidavit that these images are referring to child pornography? And the answer is yes, because as the court, or looking to the totality of the circumstances, looking at what the state judge had a substantial basis to determine probable cause, just from the 4 corners, the issuing judge knew that the affiant was a detective in the cyber crimes unit, knew that we were searching for evidence of distribution of child pornography, and that this search was searching for physical, digital, or electronic form, including computers, cell phones, and electronic devices. So more than just images, but also potentially the electronic devices used to upload those images. The issuing judge knew that there were 2 known images of child exploitation that had been uploaded to KIC, that KIC had reported these images to law enforcement, that photo DNA, which the affiant describes, and I should have referred to this, this is all taken from the warrant, which is volume 1, pages 19 and 20. Photo DNA, as the affiant describes, helps detect, disrupt, and report the distribution of child exploitation materials. One more brick that the issuing judge can use to infer that what we're referring to is child pornography or evidence of distribution of child pornography.
Does the affidavit include a description of what KIC is and why it does what it does and how it's connected to law enforcement?
It does not, Your Honor. The affidavit only says...
So the affiant could get this information from anybody. So there's no compelling weight that we should give to the fact that it came from KIC.
Not from the 4 corners of the affidavit, no. The judge, the issuing judge, may have used his reasonable inferences based on his experience and his experience seeing KIC, but we don't know that, we don't have that, and that's not necessary to find probable cause here. What we do know from the affidavit is that KIC reported these images to law enforcement. We know that the defendant has a prior conviction, and that this prior conviction is directly linked to the type of evidence being sought here. It's a prior conviction for possessing or distributing child pornography, and the affiant is requesting permission to search for distribution of child pornography.
Was it tied to computerized images? That's what you're searching for, is computerized images, and his prior conviction was also of computerized images?
What we know from the affidavit is that his prior conviction was for possessing, distributing, it's a whole host of,
right?
Yes, electronic.
It was electronic?
It doesn't say that.
It doesn't say electronic, no.
It says procuring, producing, distributing, and possessing child pornography.
So it could have just been hard photos?
It could have been, yes. But the totality of the circumstances here, where there's these known uploads from an IP address that's then linked to the defendant, give a fair probability that this is going to be electronic evidence that's being sought. The affidavit also establishes a sufficient nexus. The affidavit links the defendant to criminal activity and then the defendant to the place to be searched. As this court noted in Bigelow, there are 4 factors that can be considered for determining if there's sufficient nexus between the activity and the residence. The first 3 are the type of crime, opportunity for concealment, nature of evidence. All of these, this court has held, common sense suggests that child pornography will be secreted in the home. It's the type of crime that is, or the type of evidence that is hoarded, that is held onto, and is kept private in a private residence. The most important factor from Bigelow for this case is the 4th one, which is that Bigelow said that that sufficient nexus between the criminal activity and the residence could also occur from all reasonable inferences that the issuing judge would make as to where a criminal would likely keep such evidence. So an issuing judge can use her common sense to determine where this would be. Now, the affiant does what we would want the affiant to do. She researches, she finds out what is his address, and she includes in the affidavit that the images had been uploaded from a prior address, but that based on his sex offender's registration, he was now at a new address. A judge would reasonably infer that the type of evidence sought for here, child pornography images that we know are frequently hoarded or kept, and computers, the personal computers, personal electronics used to upload these images, it is a reasonable inference that the person would move with that evidence. In fact, it would have been unreasonable for the judge to issue a warrant for the prior address because the judge knew that the defendant was no longer at that address. And it's common sense and reasonable that the defendant would move evidence of this crime with him to his new address.
It does require us to make a double inference, though, because first you want us to make the inference that these were child pornography, images of child pornography. So first we've got to make that inference, don't we? And then once we make that inference, then we can say, well, yes, this would normally be something that would be kept within the individual's home and perhaps moved with their computer because they want to keep it private. I mean, you first need to make the inference about the images and that's the defendant's objection here and what they were.
Yes, the first inference is that this is evidence of distribution of child pornography. I think, though, importantly, and defense mentioned this a number of times, is that from the affidavit, we can't conclude that the images were illegal to possess. That's not necessary. What we're looking for here is probable cause. Whether or not there is a substantial basis that there may be evidence of a crime, fair probability that there's evidence of a crime at this address. And the totality of the circumstances presented in this affidavit. And the affidavit is not, it could have defined things better, but this court has also noted that an affidavit doesn't have to be a model of specificity. This affidavit did present enough for the issuing judge to consider the totality of the circumstances, to make her inferences, and to find probable cause. There was a substantial basis for that. However, in any event, if the evidence doesn't need to be suppressed because the executing officers, if the court disagrees or feels that there is not a substantial basis, and as the court is aware, the review here is very deferential. Really, we're just looking to whether or not the judge had a substantial basis, the issuing judge. If this court ultimately decides that the judge did not have a substantial basis, the officers still acted in good faith when they relied on the warrant that was issued by a neutral judge. The good faith doctrine, of course, is an exception to the exclusionary rule. The goal here is to prevent unlawful activity by the officers. Here, the affiant did everything she thought she needed to do and then had it approved by the judge and then did the search based on that warrant. Of course, good faith is not absolute, and there are the 4 exceptions. I'm only going to focus on the 3rd, which is the affidavit lacking in indicia of probable cause. that would be the only instance here, and that's the only instance alleged here for why good faith shouldn't apply. What this court—
Do you know if the affidavit was attached to the warrant when the warrant was executed?
When the warrant was executed at Mr. Kilgore's residence?
Right. Did the executing officers have the warrant? Have not only the warrant, but also the affidavit?
I don't know. I believe the executing officer was also the affiant. I'm not sure if that's what Your Honor's asking. But the question of whether this was not the situation where the affiant put together a bare bones affidavit, then hoping to rely on the ignorance of the executing officers. Here, the executing officer had an affidavit that had more than an indicia of probable cause. As this court noted in Bigelow, the affidavit was not bare bones. It was not devoid of any support. In Gonzalez, this court noted that good faith only requires some factual basis connecting the place to be searched to the defendant or the suspected criminal activity. When this connection is wholly absent, the affidavit and resulting warrant are then so lacking in the indicia. And that's not what's happening here. In Gonzalez, where that quote comes from, there the affiant had said, this is the defendant, he's done illegal things, and then put an address and said that they wanted to search that address. There was no connection at all to the defendant and the address. There was no, this is the defendant's address, or any other connecting information showing that the defendant was linked to the address. That's not what is at issue here. Here, the affiant clearly puts in, this is the defendant's address, and this is the place to be searched. So minimal nexus is all that's required for good faith. And the warrant establishes more than minimal nexus, as referred to with the Bigelow factors based on the judge's inferences. But this warrant was not one that was this affidavit was not one that was so lacking that good faith wasn't reasonable. Finally, any defect in the warrant would now have been missed by both the issuing judge and the district judge, which of course is not dispositive, but it further supports that the officer's reliance was reasonable. For these reasons, Your Honors, both the totality of the circumstances analysis and the officer's good faith reliance on the warrant the government would request that this court affirm the district court's ruling. And if there are no other questions, then I would cede the remainder of my time.
Hearing none, thank you. Any rebuttal?
I think once again, the warrant didn't meet the minimally sufficient nexus between the criminal activity and the place to be searched. The affidavit doesn't even describe criminal activity. What it describes are that two images were uploaded by a person with a prior conviction for child pornography, distribution or possession. So the affidavit doesn't present compelling evidence that a crime occurred, much less that evidence of that crime would even be found in this second home that Mr. Kilgore resided in. I think it's clear that the affiant could have done a lot more with this affidavit. It's not even clear from the affidavit that the affiant viewed the images. A reasonable inference to be drawn could be that she chose the phrase child exploitation material because it's what this program described the images of. I think the last thing I want to say is that it's not clear that anybody saw the images beyond this program that's either operated by KIC, by the government, or by some other internet company. Looking at the affidavit, we don't even know the answer to that question. So I think that's all I have to say as well, unless there are questions. Thank you, Your Honor.
Hearing none, thank you. Thank you both for your arguments. The case is submitted. Our last case for argument this morning is United States versus Wilson.
Judge, I'm having a problem with my camera, apparently.
Just so long as you do not appear as a cat. Do not appear as a cat, right?
Yes, ma'am.
Yeah, we don't want that.
All right.
Okay, we're ready to hear from the appellant.
May it please the court. Your Honor, my name is Neil Kirkpatrick. I represent the appellant in this case. I am going to be mercifully brief because it's been a long morning for all of us, although I've listened to some fine arguments this morning. This case arose out of the amateurish botched robbery of a Radio Shack in Broken Arrow, Oklahoma. Resulted in some very serious charges for the appellant and his comrades in this robbery. And in any event, we are now in the weeds of discussion regarding the categorical approach to certain statutes, and particularly ones in enhancing sentences. What actually happened in this case was that the appellant and his comrades robbed the Radio Shack in Broken Arrow, and the appellant, well, in any event, he was charged with conspiracy to commit robbery, attempted robbery in violation of 18 U.S.C. 1951 and 2A, possession of a firearm in furtherance of a violent crime, that is attempted robbery as specified in count 2. Now, the issue is whether or not the attempted robbery is whether or not the possession of a firearm in a violent crime can be applied to enhance the sentence in count 2 of this case, which is the Hobbs Act robbery. There was a rather convoluted pretrial. The defendant wound up pleading guilty. And anyway, this court is now permitted, after the Davis opinion in the Supreme Court, this court is now permitted to consider these cases, whether or not determine whether or not the sentence should be enhanced. Davis held that the second clause of 18 U.S.C. 924C is the so-called residual clause. And Davis held that the residual clause is unconstitutionally broad. In this case, we're dealing with an attempt to commit robbery, to commit Hobbs Act robbery, and the question becomes whether or not the residual clause of 924C is going to suffice to allow.
Well, I thought we were beyond that. We know that residual clause doesn't apply, and we need to look at the elements clause, don't we? Isn't that where we are?
Well, that's correct, Judge. Okay. If this case can't be decided under the elements clause, then we fail. We submit that the elements of 924C are, of course, the possession of a firearm while in the commission of a felony. mentioned before that this case is deep in the weeds of the categorical approach to these things. In the ordinary case, the court would examine the statute at issue here with the categorical approach.
And what happens when we do that?
Well, you have to decide the certain things. The categorical approach would be that you have to
we have to determine whether or not we're looking at a crime of violence. That is, does it have an element, as an element, the use, attempted use, or threatened use of physical force against the person or property of another?
That's correct, Judge. In this case, the question is whether or not an attempt is going to satisfy those elements. We submit that the attempt does not. An attempt under the law is defined as a person possessing the intent to commit a crime combined with an act in furtherance of the crime. Now, the question, I think the question is that if a person can commit an attempt, as attempted in this case, without the intent to use force. In other words, if
I think your brief, the way I'm reading your brief, it suggests that you could commit an attempted Hobbs Act robbery with an intent to use a threat. Maybe you could write a note and have a threat on it, but you don't actually use it. You don't actually, the threat's not actually communicated. You take other steps that are substantial steps. And I think you mentioned reconnaissance type efforts. You take those types of steps, but you don't actually communicate the threat. That's the way I read your brief anyway.
Well, that's right, Judge, and it's the way I intended you to read it. In this case, I don't think that the communication, well, in this case, there was no real force. Well,
I think it's pretty hard to say that.
No, you're right.
Held a number of people at gunpoint, tied them up, and took their money and their belongings and left with their car. I think there's a lot of force going on. I think obviously here we cannot look at the underlying facts. We have to look at the elements. So we're back to the attempt. And does that satisfy a crime of violence?
I don't think so, Judge. It's our position that it does not, because an attempt need not necessarily involve violence at all.
But isn't the attempt, when you read the charge here, isn't the attempt tied to the substantive crime? It's just not an attempt out there by itself. It was an attempt with the intent to commit the substantive crime. And we know the substantive crime is a violent felony.
Well, that's true, Judge. Your Honor, I'm going to have to stand on my brief.
Okay. We will hear from the government.
May it please the court, Thomas Duncombe for the United States. The government wins this appeal for two reasons. First, attempted Hobbs Act robbery is a crime of violence under Section 924C. Second, Wilson cannot overcome the procedural default of failing to raise his Davis claim on direct appeal because he cannot show actual innocence of both 924C charges that were brought against him. We know that attempted Hobbs Act robbery is a crime of violence because of what we know about attempt law, what we know about robbery law, and what we know about congressional intent. First, what we know about attempt law. In Rinker, a panel of this court held that attempted federal bank robbery, which can also be committed by threats, like attempted Hobbs Act robbery, is categorically a crime of violence under 924C3A. And that makes sense, given what we know about federal attempt law. And here, Judge Briscoe, I would go back to what you just brought up, which is absolutely correct. Attempt is not out there by itself, untethered to the elements of the statute. It's an attempt to commit the substantive crime. So Taylor is incorrect when it says that the crime could be committed by attempt to threaten. It's an attempt to take property from the person of another by force or threat of force. And to commit an attempt crime, a person must have the intent to commit every element of the underlying crime, and they must undertake an overt act that constitutes a substantial step toward completing the entire offense.
Why isn't reconnaissance, and we've held, I think the Pritchard case is one, I don't know that you cited it, where reconnaissance, 2 weeks observing a bank, preparing a sketch of the bank, following a bank employee home, assembling instruments to commit the crime, going to the bank manager's house, that sort of thing. It's all preparation, and that was considered enough to be a substantial step in Pritchard. Why do we have to have actual, for instance, communication of a threat?
Well, I don't think that you have to have actual communication of a threat, but you have to have the violence inherent in the crime of robbery as the object of the intent here. And so with respect to all the cases that are from the 1970s or the 1980s that have been cited by Mr. Kirkpatrick, or there was one 1984 case that was cited in the Taylor opinion. First of all, it's noteworthy that we have to go back 30 or 40 years to find a case that even comes close to satisfying an attempt using threats. But in all of those cases, they're not 924C cases. And that's significant because the question here is whether we're going to be imposing an additional penalty on someone for brandishing, discharging, or using a firearm in furtherance of a crime of violence. And while it is theoretically possible that one could conduct reconnaissance and buy tools as part of one's preparatory steps, but ultimately as part of one's completed attempt offense, if you got close enough and you had the intent to commit the completed crime, it would be difficult, if not impossible, to envision how one could brandish a firearm in furtherance of doing reconnaissance on a bank, or how one could brandish a firearm in furtherance of gathering tools or picking out your mask or talking about the plans. In fact, the imagined hypothetical in Taylor, where it's gathering supplies, where it's talking with co-conspirators, that actually sounds more akin to a Hobbs Act conspiracy than a Hobbs Act attempt, because an attempt, as we know, as distinct from a conspiracy under the Hobbs Act, requires an overt act. The 11th Circuit in Hubert has said to constitute substantial steps, the defendant must do more than merely plan or prepare for the crime. He or she must perform an objectively culpable and unequivocal act toward accomplishing the crime. And this court has said something very similar in Faulkner, which is an attempt is an act adapted to, approximating, and which in the ordinary and likely course of things will result in the commission of a particular crime. And if you look at Dominguez and Walker and several of the other cases that we've cited in our brief and in our 28J letter, common sense tells us that a defendant who specifically intends to use violence and then takes a substantial step toward that use has, by definition, attempted a violent crime. And that's pretty much a direct quote from Dominguez, but it's the same reasoning as in Walker and as in Thrower, the Second Circuit case, and as in Hill and Ingram from the Seventh Circuit. And if you look at the 10th Circuit jury instructions, it supports that. The substantial steps the jury instructions in this circuit tell us must unequivocally mark the defendant's acts as criminal. Now, when you combine that with what we know about robbery, it makes it even more clear that this particular attempted crime of violence is itself a crime of violence. And what we know about robbery is that it's inherently violent. Robbery is inherently violent whether committed by threats or whether committed by a forceful act. This court in Harris said that. The Supreme Court in Stokeling said that. In Harris, this court said robbery is distinct from larceny because of the, quote, violence inherent in taking property from the person of another against his will, end quote. So yes, Melgar Cabrera said that the force has to be violent force for robbery, but also robbery in and of itself, whether committed by force or threats, is violent. And I'll note that we didn't cite this case, but in one of the cases cited by the appellant, Bowen, in distinguishing the force required to commit witness retaliation with robbery, this court said, it's easy to imagine any number of actions that damage property, but do not have the same inherent violence as overcoming the will of a robbery victim. And that was Bowen at 936 Fed 3rd at page 1107. Which brings me to congressional intent, because we know that in conducting the categorical approach, this court and all courts have been instructed by the Supreme Court that we need to avoid construing a statute in a way that renders most of the crimes it was intended to cover inoperable. We know that robbery is a bedrock crime of violence. Stokeling tells us that it may be the quintessential crime of violence. And in enacting 924C, at least the version that was enacted in 1984 that made it a separate substantive offense, or made it clear that it was a separate substantive offense, there were only 2 crimes mentioned in the 1984 Senate report. One of them was robbery. And attempt crimes, as Walker shows us and as some of the other cases show us, are explicitly included in 924C3. And it's worth pointing out that when the purpose of 924C3 is to deter criminals from bringing crimes to potentially violent scenes, the deterrent effect on an attempted robber is exactly the same as the deterrent effect on an actual robber. Because at the time, before the crime, when the robber is thinking about bringing the gun to the crime or not, the mens rea is exactly the same. The mens rea is to intend to commit the completed crime of robbery. Yes, contrary to what Taylor said, common law robbery includes robbery by force and threat of force, and therefore interpreting the statute in the manner that the appellant would like this court to interpret it, and in the manner that Taylor interpreted it, would exclude most attempt offenses from qualifying, even though Congress specifically said we want to include attempt offenses. I want to make sure that I address the procedural default question. The appellant cannot raise a claim in a 2255 petition that he could have raised in a direct appeal unless he can show cause and prejudice or actual innocence. Mr. Wilson cannot show either. He can't show cause for cause and prejudice because the argument that the residual clause of 924C3 is invalid was as available to Wilson in 2013 when he was sentenced in this case as it was to Mr. Davis, who succeeded before the Supreme Court just a few years later. It's not cause to say...
So that you're saying his counsel could have made the same argument that counsel made in Davis?
Yes. And
haven't we in other cases, and I think even the Supreme Court said, well, that doesn't count in this particular instance. We are going to conclude that this is such a big change in law that there's no cause. Cause is not applicable.
Well, Your Honor, in Bowsley, the Supreme Court instructs that it's not acceptable to say that that particular argument would not have been acceptable to a particular court at that particular time. And it's noteworthy that there were numerous challenges to residual clauses, not only in 924C, but the residual clause in the ACCA, which is identical or very similar, all around the time that Mr. Wilson was sentenced. So the argument was available. And he can't show actual innocence because, as Bowsley tells us, you have to show not only actual innocence of the crime you're challenging, but you have to show actual innocence of an equally as serious crime that was dismissed as a result of a plea bargain. Judge Posner pointed out in Lewis that Bowsley applied to crimes that were as serious that were dismissed as a result of a plea bargain. And this court's decision in Powell shows that counts that were dismissed as a result of a plea bargain that were as serious are ones that qualify under the Bowsley rule. And in fact, in Powell, it was even stronger than in this case, or this case is even stronger than Powell, excuse me, because in Powell, the count that was dismissed as a result of the plea bargain was an 5 years to 40 years mandatory minimum drug offense, whereas the count that was challenged was a 924C 5 years to life offense. So it's true that the drug offense that the government agreed to dismiss in plea negotiations was as serious in that it had the same mandatory minimum. It was arguably less serious than the 924C. So here, just like as in Bowsley, which also involved two 924C charges, by the way, as in Powell and as in Lewis, Mr. Wilson cannot show that he is actually innocent of both of those 924C charges. And I do want to address the fact that the government did not raise that argument below, but number one, this court can affirm on any ground that even those that were not mentioned below. And number two, the factual record on this issue is fully developed, because the factual record that matters is the factual record from Mr. Wilson's change of plea hearing.
And the affirm on any reason is the idea of his having to show innocence on other dismissed counts. Is that the other, what's the theory?
Well, yes, the theory is that he cannot show cause and prejudice or actual innocence for failing to raise this argument in direct appeal. So this court can affirm the judgment of the district court, which dismissed as well as denied Mr. Wilson's 2255. And in addition, in terms of trying to prevent a windfall to a defendant, which is what Bowsley tries to make sure we avoid, this case is a particularly good candidate for trying to avoid a windfall because, as Judge Briscoe stated during Mr. Kirkpatrick's argument, Mr. Wilson did in fact commit completed Hobbs Act robbery and completed carjacking in this case. If there are no other questions, then I'll cede the remainder of my time and ask that the court affirm the district court's decision.
Thank you. Anything further, Mr. Kirkpatrick?
No, Your Honor.
All right. Thank you both for your arguments. The case is submitted. Court is adjourned until 9 o'clock tomorrow morning. Thank you.
Court is in recess until 9 a.m. tomorrow.